Teresa May. I'm the director of the Harris County Community Supervision and Corrections Department. And I'm here speaking on behalf of my department and the Texas Probation Association.
Great.
So, a couple of different things I want you to know. First, I want you to know what our population looks like that we are seeing that are suffering from substance misuse issues. Judge Thomas let you know that we started a program for first-time state jail felony drug offenses. It's less than a gram, and 1 to 4 grams are eligible for a pretrial intervention. They are first offenders. Those individuals are scoring, 80% of them are scoring in the moderate to high risk for rearrest. By definition, what that means is they have several different factors in addition to the drug problem that are driving their involvement in the criminal justice system. And if you look at this page, down at the bottom outlines the risk needs responsivity model. The factors that, in addition to substance abuse, that are key and must be addressed are outlined as criminogenic targets here. Every single probation department is required to administer, actually by legislative implementation that you all put into place in 2014. So we're all required to administer a risk assessment. We identify the criminogenic risk factors. We know what risk we are dealing with. The reason that's so important is you want to focus your most intensive resources on the individuals that are moderate to high because they are most at risk for reoffending. On top of that, you want to make sure that anyone that's low risk, that you don't overdo it with what you do with those individuals. If you do, you can actually cause harm. You know, you can actually make them worse because by definition, they don't have these problems going on. Generally, we refer, I know the time is hit, but generally we do not refer any of the moderate to high risk. We tend to put in our CSCD programs, our treatment programs run by clinicians, and we refer the lower risk individuals to the community, and we have a lot of partnerships that are great. So I'm going to stop there since we're time and let you ask a few questions, but there's some data in here that I think are really important to show that this model works. So particularly
No, I was going to say the next page, you were on the literally the same page. The RIC docket and the success of it's really enlightening yesterday, so we appreciate both the testimony that the committee received yesterday and your testimony. So where do you go from here? What's your biggest barrier to success, and what else would you like to let us know about your program?
You do have this page, and in the chart at the bottom of the page actually is very important, and what it shows is what's happened over time in Harris County. And actually, prior to the RIC docket actually started during FY17. Mm-hmm. And if you look at this chart, the red line are the total Harris County State Jail commitments. If you look at the chart, you can see that the numbers started dropping in 2015, 2016, and then have continued to go down. The bars are the placements on community supervision and pretrial intervention. So you can see as the state jail commitments have gone down, the population that we are treating, providing services to have gone up. It's a huge drop. And it's a cumulative impact from making sure we're implementing the risk needs responsivity model, starting the pretrial intervention program, which is what happened in FY16, which gives, Judge Thomas explained yesterday, first offenders an opportunity to go through 1 year and not end up with a criminal conviction or a criminal arrest on their record, and all the way to the RIC docket impact that you will see in 2017, 2018. That has really turned around our numbers. As he said, 80% of the individuals are taking pretrial intervention or probation.
Right. Chairman White, before Representative Navarez.
Thank you. Appreciate your testimony. Would you agree, and if you don't, then tell me why you don't. Would you agree that the crimogenic targets are the end-all be-all of how successful the rest of this goes?
Absolutely. That is absolutely important. One of the things that happens historically before we knew about criminogenic risk targets is, when you sit down with a person, and I'm a clinical psychologist, if you don't know, licensed psychologist, and I spent years assessing people. And when you sit down with individuals that we see, by the time they end up with us, there is a lot of problems going on. And you could end up running down a lot of rabbit trails trying to fix things that actually aren't going to impact the recidivism. And what this does is we do an individualized assessment. The criminogenic targets really do tell us what is it that's keeping this person engaged in the system. And clearly substance abuse and addiction is a piece of it. But it's also the lifestyle, their friends, their employment, their attitudes. All of that has to be addressed together.
Now, that being said, and based on the presentation, because it seems very well fleshed out, do you feel that there's enough resource for that to be able to get done? And I'm talking about from the way the assessment's created to the way it's applied.
Yes, sure. So, absolutely. So we validated, you start with a risk assessment that actually measures risk and measures these criminogenic risk factors. In Texas, one of the things I'm very proud that we did is we validated a very good risk assessment tool that does that on the Texas population. And as you know, we are a very diverse state. And it worked out very well. It predicted new arrest and did it in a very powerful manner, which is what you want from your risk assessment. That has been implemented across the state. Every single probation department has that instrument and is required to do that. And actually, again, this body put that in statute because it was that important. As the model's applied, there's a lot of training that goes into it. All of our treatment programs that are cognitive behavioral, and they're run by clinicians, a few things are run by master's level and doctor level clinicians. Those programs are specifically designed to target addiction and target these risk factors. There are responsivity factors, sir, that are more the barriers and other things that are individual that you have to address. So we do have individuals that have a co-occurring mental health problem. We partner with our LMHA. In fact, they are on site at my residential facility, helping me with that population. We partner with our local hospital district, who is also on site with us on the medical. So we are addressing those kinds of barriers as well. And there are other factors, transportation, child care, cognitive deficits, that all get taken into account. But it starts with a good assessment and good training and good programs.
Thank you.
Chairman White?
Yes, thank you very much, Mr. Chairman. Just a few quick questions. Thank you for your testimony, Dr. May. And, when I've listened to folks talk about these types of responses or programs, one thing I hear from the field is, getting the justice-involved person to accept probation. That somehow they get some type of legal counsel, maybe from a fellow justice-involved person, or maybe from licensed legal counsel. There are barriers like fees, and you can just go here after you sit in the county jail for 4 or 5 months, and then go sit in the state jail for 4 or 5 months, and you're done. So mechanically, how are you dealing with that?
Great question.
Okay.
The very first page, just real quickly, the data that told us what we really needed to focus on with this docket are outlined here. When we entered into this, and by the way, this was all created as part of our Criminal Justice Coordinating Council, which required every single stakeholder in our system to participate. DA, judges, defense bar, us, and we had to get in a room and come up with this. We looked at the data, and it was very telling. One of the things we found, again, it was alarming that 80% of these individuals were opting for time. And when we looked at our jail data, what we found out is the overwhelming majority of the people opting for time had been sitting in jail almost 4 months. And then when you add on back time, or you get a 1244A, which is a felony conviction, and you're able to do county jail time at 3 for 1, you're walking out the door pretty quick. And that's very attractive to someone who's addicted to drugs and has other issues. I can get back to using really quick. We did away with that. So in Harris County, The judges have created a system to where a number of individuals are released presumptively. So money is not a barrier to being released on bond.
Okay.
So there are certain variables at play with that, but many of them are released presumptively right off the bat. A number do bond out on surety bond. In addition, we do not let anyone left book all the way up into the jail. The sheriff actually holds them down. They see Judge Thomas the first thing the next morning, and he releases pretty much everyone else on PR bonds with conditions. And they have their court dates, they get their instructions, and we're ready to go. That has made a huge, huge difference because they're not sitting. You know, if you set 4 months, for them, time is a commodity. I mean, you know, they can do the math. Judge Thomas says that a lot. He says, you know, they can do the math. One of the things we face when we walk in and we're talking with individuals, and it wasn't uncommon early on because I was so engaged with this, for Judge Thomas to say, hey, you know, we have a heroin addict, they're shooting up every day. They are eligible for a pretrial intervention, and they don't want it. They want to take their time. And he says, you know, he always tells me, because they're listening to the jailhouse lawyers in the holdover cell. So they're doing that. Their counsel and sitting with the lawyers and talking to the clients. When actually I get to that point, sometimes it's really awkward for them in explaining how all this works and helping them understand, you know, fees aren't a barrier.
Okay.
And I'll be honest with you, sitting across from these individuals, and I've done this many times now since this court's inception, I've never had anyone bring up fees. Now, Judge Thomas, when he talks to them, he always says, do not let that be a barrier. And if you look at our collections, you will see that that's not an issue.
Okay.
Our focus is on getting them well.
Okay.
And particularly with the opiate users, which has been a very big concern. It's about 8% of that population. It's about 6% of my probation population overall. Mm-hmm. Most of them are using heroin. And most of them are shooting up daily. You know, 1 to 3 grams daily. Mm-hmm. They're at risk to die.
Okay.
And that's the conversation we have.
Okay, well, that's an interesting narrative. Reading through the newspapers, we hear about all this litigation going on in Harris County with bail, and you know, there's a thought out there that these folks are not coming back. You know, it's just really just chaotic. So, how are we able to get them to come back and report and do what you asked them? So,
yes, everyone's seen the news, and a lot, you know, the misdemeanor cases, one of the things when you hear they're not coming back, this is a separate issue. The part of the federal court order said any misdemeanor that's not released in 24 hours will be released by the sheriff. And what happens with that particular case is that individual doesn't get the same process and communication as they do when they're released presumptively or in the magistrate court. So sometimes it's a little confusing. The sheriff's department's not prepared to do that. You know, they've adjusted. So there's a lot of confusion on court. They don't know how that works. They don't know how court day works. It just was an added burden to them. Okay. So that's really what we're talking about there. I'm talking about the felony cases. Mm-hmm. And we did spend a lot of time, and actually prior to this lawsuit, the felony courts, even the misdemeanor courts, were working on improving our release process. We implemented the Arnold tool, which most of you have probably heard about, which is a help. But they also set up specific standards on individuals that nonviolent, not at risk to the community, that could be released presumptively, and a good bit of these people can be.
Okay, and we have no sensational news reports about being released out on bond, on community supervision, something very, very bad happening.
Well, here's what I will say. None of the individuals that I know of at this point that have gone through this docket has that occurred. Okay. However, our risk assessments, you know, when I say someone scores low risk, what that means data-wise is 1 in 10 are going to reoffend. Problem is, I don't know which one. Okay, because we're looking at groups, and that's the same way medication is. It's the same way every scientific study runs. So there's always a possibility for one case out of thousands, you know, to have something bad happen. That's a possibility.
And you know, talking out in the field, you know, because this is public safety we're dealing with, that a lot of these folks, on paper it may have been a drug possession, but really they slapped their spouse. They had whole lots of guns that they were shooting, so they had a whole lot of other charges. So how do you reconcile?
So in those situations, so the district attorney certainly has full discretion on what they will take.
Okay.
For the pretrial intervention, there are individuals that do have other factors going on, and you can get the pretrial intervention if you have misdemeanors, but they do exclude on certain different factors, domestic violence historically being one, but I will tell you they're rethinking that.
Okay.
So that's our district attorney's call.
Okay.
Individuals that have multiple charges at once, including drugs, they're going to more than likely end up in the other courts, unless, if the other offenses are very serious.
Okay, so these are strictly just possession cases?
PCS, less than a gram, 1 to 4 grams, and prostitution, 4th.
Okay.
But they can have misdemeanors in their history.
Okay.
But generally, if there's other felonies, they're going to a regular the highest offense is going to take the lead.
Okay, right. And one thing I get a lot is, how do you get everybody in the room? I'm talking to a probation chief somewhere in the state, and they said, Rep, I get it. This is the way to go. But how do you get all the stakeholders? Who's the leader on that?
The coordinating council started before I came to Harris County by El Franco Lee, one of our commissioners. And if anyone knows El Franco Lee, he was very subtle in how he talked, but you listened to him. Our commissioners court created the council, and obviously a lot of the people sitting at the table are funded by the commissioners, so that certainly is a factor. But to be honest, when we sat down and we really started looking at what was happening with our population, Judge Thomas talked to you a little bit about it yesterday. Everyone wanted to change something. Now, were we all on the same page on the how? No, but the data got us there. And that was really, really important. And I can tell you, it opened eyes. We pushed up our sleeves and we worked hard. El Franco certainly had us reporting out. Now, and the council meets, we meet every month, or every other month, actually.
And you have it here, and your outcomes, summarize your outcomes as far as rearrest rates and whatnot. Those are...
So if you look at the first page,
Okay.
This chart down here was one of the things that really caught the attention of our individuals that are in the courtroom, the defense lawyers, the prosecutor, and the judges. And I know Carrie testified yesterday that the average rearrest rate's about 62%. Ours is about 13%. What I did when I came to Harris County is I looked at 40,000 cases, and actually I've had some other people analyze this data with me, so it's not just me. And we controlled for criminal history and created a risk proxy, and actually current offenses at arrest and age. And if you look at it by risk, so we're comparing now apples to apples, because one of the things I heard a lot from district attorneys is probation gets the easy cases.
Yeah.
No, that's not true. When I control for the total number of priors, the history, and those factors that predict risk, 71%, you can see at the high end, are rearrested, and the median time to rearrest was 9 months from disposition, which means they did their time and they walked out and they got arrested again on another state jail felony. So clearly, and you can see that probation is significantly lower for the same person. And the big difference, the risk needs responsivity model.
Okay.
You have to look at the person, you have to get them what they need, the services they need, you have to partner with the community. And that's what works. And both the SAMHSA and NIDA, which National Institute of Drug Abuse, and I know y'all are familiar with SAMHSA, actually report out the risk needs responsivity model is the model to use for this population. And it is designed to function in our system. And we do a good job of sorting out, who can I send to the community? Community does a lot better when I'm sending them the right people.
Okay. And I've tried, Dr. May, to just try to analyze this and say, why wouldn't it work? What would happen if it would not work in other parts of the state? And pretty much the only thing I can come up with is we would probably pay less for the same bad outcomes if it didn't work.
All right.
Thank you.
You're welcome.
Any other questions, members? Thank you, Dr. May.
Thank you.
Thank you for
Thank
being
you.
here. We really appreciate your testimony.